second president and one of the founding fathers. Yes, I know I've been out of office for quite a while, actually about 200 years, but apparently I'm still relevant. The American Bar Association chose my legacy as the theme for this year's Law Day celebration. So I felt it was only appropriate that I make a personal appearance at this Law Day live event. I always believed in the rule of law and the fundamental right of those accused of crimes to have legal counsel. But I defended the British soldiers charged in the Boston Massacre, which I recall thereafter was one of the best pieces of service I've ever rendered in my country. Today I understand the issue of access to justice is still in controversy. This time involves the detainees at Guantanamo Bay. Now they tell me I'm talking to people all over the world. You can talk back for the next 2 hours through some things called Twitter and Facebook. In my day, it took a fast horse and a guy named Revere to get the message out, and that was anything but instant. All this technology, of course, is beyond me. I've spent an entire morning just trying to understand ballpoint pens.
Hello, and welcome to Law Day Live. I am Supreme Court Justice Nancy Seda. Today is going to be an innovative, interactive, internet journey into the controversial issue of military tribunals and the greater, most important issue, justice for all. Law Day, every May 1st, is our nation's celebration to mark our commitment to the rule of law. First, President Dwight D. Eisenhower established Law Day in 1958. In 1961, the Congress designated May 1 as the official date for celebrating Law Day. In Nevada, one day simply is not enough. In fact, we have gone so far to designate the month of May as Law Month. We believe this is our opportunity to open the doors of the justice system to students here and in classrooms and to the public all across the state. This year's Law Day theme is the legacy of John Adams from Boston to Guantanamo. Hi, John. I'm sorry to say, Mr. President, Law Day is really not about you. We're pleased that you provided some of the benefits that you hold dear, access to justice and the rights of the accused. But we're proud to show you that regardless of how notorious our defendants have been over the years, we continue to carry your word and your commitment to justice. I am pleased that you have joined us, but I have no idea how you got here. And I hope you approve of what this country has done since our justice system has become a different place. Law Day Live connects panels in 3 Nevada communities. Here in the Supreme Court courtroom in Las Vegas, at the Supreme Court building in Carson City, and the Humboldt County Courthouse in Winnemucca in north central Nevada. For the next 2 hours, we will all be as if we were in the same room. We will explore one of today's controversial issues, and in fact, a very timely issue in light of what has happened in our country in the last few days. How should this country bring alleged terrorists and other so-called enemy combatants to justice? After British soldiers fired on protesters in Boston in 1770, which became known as the Boston Massacre, John Adams stepped up to defend the 9 British who were accused. This case was notorious, and John Adams' defense of them was very unpopular. But John Adams, thankfully, set a standard, a very high standard, that continues today. Our justice system must provide justice for all. We will begin Law Day by showing the highly acclaimed film, The Response. It is a courtroom drama that places the audience inside the tribunal process at Guantanamo Bay to see and hear exactly what that court heard. The Response was shortlisted for the Academy Awards in the Best Short Film category, live action, and was one of only 10 films so nominated. It won the American Bar Association Silver Gavel Award as the best year in drama and literature. Prior winners should be familiar to you: 12 Angry Men, Judgment at Nuremberg, and To Kill a Mockingbird. The response has already been screened at the Pentagon, before Congress, at the Department of Justice, Harvard, West Point, UCLA, the French Embassy, and the U.S. Army JAG School, among many others. To learn more about this film, please go to the Law Day Live page on the Supreme Court website. At the end of the film today, our audience will decide for themselves whether a detainee provided material support to Al-Qaeda or is just a victim of circumstance. This film is based on actual transcripts from Guantanamo Bay. After the film, you will be able to participate in our Law Day Live discussion. If you are a student watching this in school or at one of the 3 locations or anywhere else, anywhere in the world, watching this live on the Supreme Court website, you may participate actively with us here today by commenting or asking questions through Twitter or Facebook links. I want to bring back President John Adams to see if he has learned anything.
I think I need to study up on my Facebook and Twitter skills.
I share your concern, Mr. President. You can find us on Twitter by typing the @ symbol and John Adams' name, John Adams and me. Please add a hashtag to your comments, the number sign, and the word Law Day Live to your comments so everyone can follow our conversation. You may also find our president on Facebook. He has his own page, John Adams, Nevada. Please join us in commenting or talking to John Adams. Our panel here in Las Vegas includes District Court Judge Rob Baer, who participated in courts as court martials as a member of the Judge Advocate General Corps before becoming a district judge here in Nevada. We also have joining us today Mary Brown, the Chief Deputy District Attorney in the Juvenile Division of our court system in the 8th Judicial District. And we also have with us Bill Cohn, the Clark County Public Defender. I would also like to draw your attention to the writer and producer of the response. Sig Libowitz is joining us via video from Washington, D.C. The response is something that we thank you for, Mr. Libowitz, and I hope that we can do justice to your controversial subject as we proceed through Law Day Live today. Here in the Las Vegas courtroom, I also have the privilege of hosting Union Springs and El Dorado High students. Additional students will be participating from their classrooms at the Advanced Technology Academy, El Dorado, Las Vegas, and Liberty High Schools. Now, I would like to go to Carson City, where Nevada Supreme Court Justice James Hardesty will introduce and lead his panel. Justice Hardesty?
Good morning, Justice Seda, and good morning to everyone in Las Vegas and in Winnemucca. I'm Jim Hardesty. I'm a justice on the Nevada Supreme Court. A primary purpose of the Nevada Supreme Court is to ensure the rights of the accused and that they are protected and their interests of justice are served. Primarily, we do that through our written decisions and opinions. During the last year, however, we've decided more than 2,400 cases, with about half of those cases being criminal cases. The Supreme Court, however, has done more than that, more than just decide cases. We have adopted and created commissions that focus on openness and access to justice, including an Access to Justice Commission and the Indigent Defense Commission, both of which have had major impacts on the justice system in Nevada. The Indigent Defense Commission recommended rules that we adopted requiring defense attorneys, to follow certain steps in their representation of criminal clients. This ensures that defendants have sufficient opportunity to assist in their defense, and the attorneys are as prepared as possible in cases when they go to court. The Access to Justice Commission, which I co-chair with Justice Douglas, has worked to open the courthouse doors in civil cases for those who do not have the funds to be able to represent themselves in those case types. And litigants in rural courts now have the opportunity to participate through video and telephonic options for court appearances, something that's been new to Nevada in the last couple of years. Civil law self-help centers in urban courts assist those who cannot afford a lawyer and are representing themselves. In Carson City today, Justice Seda, and we have Carson City District Attorney Gerald Gardner, who's seated to my right, participating as a panelist. And we also are privileged to welcome to the Nevada Supreme Court building here in Carson City the students and teachers from Virginia City High School, the Muckers. Let's hear it for the Muckers. All right. I'm also privileged to introduce Mr. Everett Shropshire and his wife Marilyn. Everett was the Teacher of the Year in 2010 in history, and we're honored to have him here. And that is quite a distinction for him and for the Virginia City High School students. And now I'd like to shift the program up to District Judge Michael Montero up in Winnemucca. Good morning, Judge.
Good morning, Justice Hardesty. Thank you, and welcome to everyone both in Carson City and in Las Vegas. We here in Winnemucca are very honored to have been selected as one of the sites for this Law Day program, and we have a full courtroom today, which I will introduce in just a moment. First, to introduce myself, I am Michael Montero, District Court Judge here in the 6th Judicial District in Nevada, which encompasses Humboldt, Pershing, and Lander County. I serve as one of 2 district court judges in this district, along with Judge Wagner. In many ways, it's more challenging to ensure access to justice in our rural courts, probably more difficult than in Clark County and Washoe County, due to the large land areas that we cover. The rural counties also have fewer resources, fewer funds, smaller budgets, and fewer attorneys. Yet crimes still occur. Our residents still seek divorces or have civil disputes that the courts must resolve. On a regular occasion, we also have the added responsibility of travel. I travel to the courthouses in Battle Mountain and Lovelock on a regular basis, as well as Judge Wagner traveling from his main office in Lovelock to the courthouse here in Winnemucca and also up to Battle Mountain. This is not unique to just our district. There are 4 other districts in the state of Nevada in which the rural judges must travel to other county seats to hold court. We are very pleased today to have a number of individuals with us that I'd like to introduce. First, I have Judge Gene Wombolt, who is with us today in the audience. He is Justice of the Peace here in Humboldt County, and welcome to Judge Wombolt. On the panel today, here first starting to my right, we have Humboldt County Public Defender Matthew Sturmitz. Then to my left, I have Michael McDonald, District Attorney here in Humboldt County. And with Mr. McDonald is Mr. Kevin Pasquale, who is the Chief Deputy District Attorney here in Humboldt County. We are proud today in Winnemucca to host 30 students from the Winnemucca Junior High School under the leadership of Ms. Worthland. It is the Junior High Leadership or Student Council that is with us today. We also have from McDermott High School. McDermott is roughly 70 miles north of us, and they have come in today to participate. We have Ms. Topholm, a social studies teacher, and we have 7 students from McDermott High School. And I understand we have approximately 24 students from Lowry High School with Mrs. Hill, who is in attendance with them. Also, we have today a couple of members of our local press that I'd like to recognize. We have Pam Victory with the Humboldt Sun and Dee Holzel with the Silver Pinion Journal. So well represented in all areas. Thank you to everyone here in Winnemucca for attending. And now I'll send it back to Justice Seda in Las Vegas.
Thank you, Judge Montero. Thank you, Justice Hardesty. Before we watch the response, I would like to recognize two very important members of our judiciary who will be honored during Law Month. The Nevada Supreme Court traditionally kicks off Law Month by presenting the Legacy of Justice Award. On Tuesday, before the en banc court, the whole court, we were able to present retired Justice Cliff Young, who was on the Supreme Court bench for 18 years, with the Legacy of Justice Award. Justice Young was more than deserving of this award. In fact, in addition to his 18 years on the bench, he served as a United States Congressman and a state senator. Later this month, as part of the Law Day celebration, the Clark County Bar Association will present the 2011 Liberty Bell Award to Chief Justice Michael Douglas. He, with Justice Hardesty, co-chairs the Supreme Court's Access to Justice Commission. I would also like to acknowledge Steve Sebelius, who is here in the Las Vegas courtroom with us. And we are going to move into the viewing of the movie, The Response. I want to remind you, as you watch the response over your computer, if you are not with us live, you may experience, as you do with YouTube videos, some pauses. Just be patient. The system will buffer. The stream will start up again when the download catches up. I also want to draw attention to the fact that Mr. Libowitz is still with us patiently in Washington, D.C., and thank you again, Sig, for being with us. We'll look forward to hearing your comments when we proceed through the movie. At this time, we will view the movie, The Response. To say that was a powerful and thought-provoking film would perhaps be underestimating what we were just able to see. In a moment, we're going to go to Mr. Libowitz to begin our discussions. First, we have John Adams, again, to remind you how you can participate if you are not with us live in any of our courtrooms today. People are watching worldwide. Mr. President, would you please invite them to join us with a tweet?
Okay, here's what you must do to join today's conversation. And I do encourage you to participate in this discussion from your classrooms or wherever you are. You can ask questions or comment on Twitter by typing the @ symbol in my name, John Adams, MD. Please add hashtag to your comments, the number sign and the words Law Day Live to your comments so everyone can follow the conversation. You can also find me on Facebook. I have my own page there under John Adams, MD. Please leave me a comment.
Thank you, Mr. President. Before we go to our esteemed panelists, I'd like to take an informal poll, and I would ask both Justice Hardesty and Judge Montero to do the same thing. It's important after we review the movie, and they left, of course, the question to us to determine whether or not this is a combatant who should face further proceedings. I'm going to ask each of you who are here today, and the other students as well, how many, just by show of hands, there's no right or wrong answer, how many of you, if you were sitting as a member of the tribunal, would vote to find that the detainee was an enemy combatant, given all that you saw in the movie? How many of you would vote that he was a combatant? In our courtroom here, I saw only two hands. Justice Hardesty, Judge Montero?
This is Justice Hardesty. None of the members of the Virginia City High School class voted that he was an enemy combatant.
Judge Montero.
Justice Seda, I think we had about 3 hands raised here in the courtroom in Winnemucca.
Again, I want to stress there is no right or wrong answer, and I think that this is the most important part of our law day, and that is to encourage your participation, to talk about the procedure, to talk about how we observe rules of law, presentation of evidence, and an opportunity to be presumed innocent in our courtrooms today. Mr. Libowitz, as the creator, director, and I noticed actor in the film, is there some comment that you would like to start with? Talking to our students across the state of Nevada.
Well, first of all, I just want to say thank you so much for including me in the film there. It's really an honor. Obviously, I want to congratulate Justice Young on his winning the Legacy of Justice Award and all your years of service. That was great to hear. I'm here. It's really an honor to be here, and we've taken this film across the country, and we think something that's so important is to do exactly what's happening now, is give an opportunity for people, and particularly students, to see it and talk about these ideas. So thank you, Justice Seda, for the opportunity.
I'm going to start with the panel here in Las Vegas and ask our three panelists here just to briefly comment first on where they fit into the system and how their jobs, obligations, and responsibilities may be similar to or different than the tribunal that we saw here in the film. Ms. Brown.
Good morning. I'm Mary Brown. I'm the Chief Deputy District Attorney for the Juvenile Division in Clark County. And what my division does is we actually do two things. First, we prosecute juvenile offenses. So kids who are accused of committing an offense, we have quasi-criminal proceedings where attorneys are attached in most cases, and it really is more like a trial. But we also do child protection cases, or what we call dependency or child welfare. And what that is those are families whose children are considered in need of protection, and some of them are removed by CPS. Many of those families do not have attorneys. They're entitled to adjudicatory hearings where the rules of evidence are much more relaxed, and so we do consider some hearsay evidence and that sort of thing. So while our hearings look nothing like that, they are allowed to challenge the evidence. They are allowed to access the information other than the information of a reporting party over CPS. There are much less stringent procedural and representation requirements.
Thank you, Ms. Brown. Mr. Conner, on behalf of the Public Defender.
The Clark County Public Defender's Office is a group of approximately 100 lawyers. We defend people who are accused of crimes and who do not have the means to afford counsel. Prior to having this job as head of the office, which I've done for the last 7 years, for the 12 or so years prior to that, I defended people charged with capital murder. I defended death penalty cases. I defended or I supervised lawyers who defended some of the most notorious crimes in the last 20 years in Clark County. So although I can't say I ever was in the position of defending someone accused of terrorism, we certainly have defended people who were less than popular. So I can't claim to do what President Adams did and defend 4 British Redcoats accused of killing 4 innocent citizens. I have certainly defended people who, at least in our community at the time, were somewhat unpopular.
And Judge Bear, you wear 2 hats. You've been in the military tribunal, and you are presently a member of our judiciary. Comment?
Well, thank you, Justice Seda and Justice Hardesty, for inviting me to this event. Really, it was an incredible pleasure for me to be here because 22 years ago, I started my legal career by joining the United States Army JAG Corps. And I noted something that, it made my heart skip a beat just for a moment here today, because when you look at Mr. Libowitz's film, you see the 3 JAG officers on that panel. And John Adams, you'd be proud of what we wore as JAG officers. You might notice that there's an epaulette that JAG officers wear. It's the epaulette that we're honored to wear as we serve in the United States Army JAG Corps. And that epaulette is a sword and a quill pen. So we did get your quill pen in there, Mr. Adams, President Adams. And I also find it interesting that 2 of the members of the tribunal were colonels in the JAG Corps, but ultimately it seems like the captain of the JAG Corps, of which I was a captain in the U.S. Army JAG Corps, is now left with the task of deciding what to do. I bring to the table, as far as my prior hat, something that is fun for me to revisit now after all these years, and that's the fact that at the United States Army JAG Corps School in Charlottesville, Virginia, where this film is being shown, I was trained specifically in the area of operation law. It turns out that there is a well-established body of law that starts with the idea of the Geneva and Hague Conventions. All civilized nations are parties to these conventions, and there really is a body known as the law of war. And at the time, 22 years ago, when I was trained, we learned about the types of weapons that you can use in warfare and things that you cannot use in warfare as weapons because they're too harsh and too brutal and inhumane. We learned about the type of targets that you can address in warfare and those that you cannot. Of course, the main objective there is to limit civilian casualties, and you don't blow up churches and museums, and we try to respect that as part of our obligations as civilized nations. You also have the idea of humane treatment of prisoners, and it really made me stop and think, what really is happening here with Guantanamo? The idea is, as it stems from law, law evolves, and all the high school kids here, let me tell you something, get involved with law if it interests you, because it is wonderful. It will take you places. Law evolves, and this is an example of how law has evolved. Events occur in human existence. Sometimes they're shocking. Sometimes they're tragic. Sometimes they're unbelievable if you saw what happened over just the last few days with the Bin Laden situation. The fact of the matter is the law will ultimately guide you, and I really think what's going on here is an attempt to sort of figure out legally what to do in the modern battlefield that we have. It's changed. Is Bin Laden in a cave? Is he in a compound? Who is the enemy? They're not out in an open field in tanks anymore. They're in weird places, and they're doing crazy things. And 9/11 did change things. And that's cause to think about what we're supposed to do to capture, identify, and detain the enemy. And that's really what the law of war has always been about, and now the law continues to evolve to address it today. In the situation that we have today, how are we supposed to let the law of war evolve into this modern battlefield after 9/11 and dealing with Al-Qaeda, terrorism, and such? And I think that's really what Guantanamo and all the procedure in the Supreme Court cases relevant to this have the really tough task of trying to do.
One of the comments that you're making is consistent with a question that we had from Twitter. And before I go to Judge Montero and Justice Hardesty to allow their panelists to comment, I think a pretty accurate comment based upon the vote that we've taken in our three venues. One of our Twitter feeds says to us, quote, "The tribunal was completely pointless." I think that's a pretty good statement, at least according to the vote that we took here. I noticed that one of our public defenders here, Mr. Cohen, would like to speak to that. And then we'll go to Judge Montero and Justice Hardesty.
Yeah, with all due respect to Judge Baer, when he talks about the law evolving, and the law does change, there's no doubt about it, but when we stand the law on its ear, and especially we let it evolve because of a horrible situation, one of the great comments that is made by the movie is that 9/11 does not define us. It's how we respond to 9/11 that should define us. And I think throughout our history, we've had horrible situations that we never faced before, like we are now, as Judge Baer points out. There was a guy named Fred Korematsu in 1942 who was an American, born in America, happened to have Japanese blood in him. And so we took him away from his house, and we wanted to put him in an internment camp. And he said no. And we went to the Supreme Court. And the law was military law, and the law evolved. And I think when we look back on it, it's not one of the better days in our history. And we look back at a few years after that, the law evolved because of the fear of communism. And so we had something called the House Un-American Activities Committee. And at least 300 people in Hollywood lost their jobs and their livelihood, including Charlie Chaplin and Langston Hughes, because they wouldn't testify. The law is evolving. And then there's a new movie out by Robert Redford that I highly recommend. It's called The Conspirator. It's about the trial, the military trial, again, of Mary Surratt, who was not an enemy combatant. She owned a boarding house in Washington, D.C. at the time of the Lincoln assassination. This was a horrible time. There's never been a civil war. And again, the law was evolving. But every time we evolve the law, and we change the law in response to something horrible, history judges us very harshly. And I hope that when this is over, if it's ever over in my lifetime or your lifetime, we'll look back on this time and we can be proud of what we did and say we applied the rule of law.
Thank you. Justice Hardesty.
Yes, good morning. I'd like to introduce Mr. Gardner and ask him for his comments. He shares those views from the perspective of a prosecutor, but also from the perspective of a lawyer who's dealt with a number of criminal cases. Joe?
Thank you, Justice Hardesty, and thank you, Justice Seda. I am Gerald Gardner, and I'm actually the Assistant District Attorney in Carson City, so while I appreciate the promotion, I would be in trouble with my boss, Neil Lombardo, who is the District Attorney, if I did not correct the record on that. So it's a pleasure to be here. The film, what we do as prosecutors, of course, is we bring charges against people who are accused of crimes. We bring them to court, we present evidence, and if we convict them, we seek punishment or sentences against these people. And the film was very affecting to me as a prosecutor. It really brought home to me the fact that prosecutors have just as much obligation, if not more, to guarantee the protections of the Constitution, of due process to the accused. I know we'll discuss this more, but there's no question that this particular military tribunal, the accused does not get the same due process that an accused would get in an American criminal court on our soil. And I think one of the most significant comments that I heard from the character played by Peter Rieger, the colonel, was how can we take the moral high ground in being a country that's at war to fight these, to protect these principles, when we're not willing to give these same protections and freedoms to the people who are accused in the military context. So it was a very affecting decision to me, or a film to me. Made me think an awful lot about our duties as prosecutors. We don't want convictions reversed. We don't want to be accused of misconduct. And above all, as prosecutors, we don't want innocent people to be convicted of crimes or wrongdoing. So thank you again for having me here.
Justice Seda, I'd like to add one comment in terms of the relevance of this subject to all of the high school students that are tuning in and those that are in the courtrooms, including here in Carson City. This detainee was detained for 4 years when probably most of you kids were maybe even in elementary school or just starting, probably in elementary school. The point of this is the resolution of these kinds of problems, these kinds of disputes, are going to occur on your watch, not on our watch. The importance of your involvement in this subject and your opinion about how it gets resolved can't be overstated. I know all of you are gearing up for finals and probably more looking forward to proms and graduation. The fact of the matter is, this is happening now. With the death of Osama bin Laden on Monday, all of these events and the decisions about how to deal with them are going to end up ultimately being made by you, not us. So we appreciate your participation. Judge Montero?
Thank you, Justice Hardesty and Justice Seda. I'd like to take a moment to allow my panelists here in Winnemucca to introduce themselves and talk just briefly about their roles here in our community. I'm first going to turn to Mr. Matthew Sturmitz, our public defender, and give him an opportunity to speak.
Thank you, Judge Montero. My name is Matt Sturmitz. I am the Humboldt County Public Defender. I came on board here in July of 2007 after 20 years of private practice up the river in Elko. And, you know, apart from, I guess, the obvious plight of these gentlemen in Guantanamo, I think this DVD brings to me a a realization that we need to remain, vigilant even locally, because the difference between what we have in our country, in our state, and even in our county in Winnemucca here, our courts, is a process that assures fair play. And if we start skirting the rules or not abiding by the rules, or we as defense counsel perform in simply a perfunctory fashion, we can create a process that does not work much better than what they have in Guantanamo. Thank gosh we have a much fairer process, but what this really brings home to me is a need to continue vigilantly to protect the rules we have in place here in the United States to make sure that all of our citizens are afforded fair play when they're accused of crimes.
Thank you. And at this time, I would turn to our Humboldt County District Attorney's Office, Mr. McDonald, Mr. Pasquale.
Thank you. I'm Mike McDonald, Humboldt County DA. I'm newly elected and took office in January. Prior to that, I worked in private practice with some criminal defense and juvenile defense work, and additionally have experience working as a deputy DA prosecuting adults and juveniles here in Humboldt County. The interesting thing that I noted from this movie is the balance and more importantly the struggle for balance between national security, trying to identify the source of the terrorism or the threats to our citizens. We keep talking about 9/11, and that was an attack on us, but we have not still to this date really defined the war that we're fighting or the individuals who are fighting, and this is an investigation that goes from virtually every corner of the world. We are looking at different cells of Al-Qaeda or Taliban or other groups to see what their involvement with terrorism is, and it's an extremely difficult balance between one individual's rights and the process versus protecting the integrity of the investigation so that we can obtain a result like finding bin Laden. So that was my observation.
Mr. Pasquale?
Thank you, Judge Montero. I'm Kevin Pasquale. I work for Mr. McDonald. I've been a lawyer for 25 years or more. What I think brings this film home, or what should bring it home for our audience, is that tribunal was not trying to determine guilt or innocence. They were trying to assign a status to the detainee. And most of the people in this room have already been assigned a status as juvenile, as student, and based upon that assignment of status, you're subject to offenses that the panel here certainly isn't. You can be charged with MIC or truancy based simply upon that status. And that's what that tribunal was trying to do, was assign a status to then progress to the guilt or innocence phase.
Thank you. Justice Seda, we'll send this back to you.
Thank you, Judge Montero. I'm going to move to a different microphone. Thank you, Judge Montero, Justice Hardesty. Before we allow or engage our students across the state in their questions, a question came to us from Twitter that I'm going to pose to John Adams, but while the President is coming to the microphone, Mr. Libowitz, a question for you, sir. What was the reaction when your film was viewed at the Pentagon and Part 2? How has the focus of your film changed, if at all, since the events of this past weekend and the capture and killing of bin Laden?
Let me take that in reverse order, if I may. How has the film changed in the past weekend? I would say really not at all. And I think this is really a key point that we all have to address. Unfortunately, people conjoin a lot of what's going on in the quote-unquote war on terror. There is absolutely no doubt that there are members of Al-Qaeda there is the Taliban. There are people out there, there are terrorists out there that want to hurt us, want to kill us, and want to do more types of events like 9/11. And I think we can all agree that the terrorists should be punished to the absolute, greatest extent possible. But what we have to remember is also there are a lot of people who are suspected enemy combatants. And suspected is, I think, the key word. How do we determine who really is a terrorist, who really is a threat to this country, and who is not? And what we hope to address in the film is that very issue. And by conjoining and saying, everyone is a terrorist, or, if the idea was, as we were told, that Guantanamo housed the worst of the worst, and everyone there is a terrorist. As we have since found out, a lot of people there were simply at the wrong place, wrong time, gathered up. As we talk about in the film, there was the bounty system that was created, where literally leaflets were dropped, over Afghanistan, telling people, you can take care of your village for life, and you can have, $5,000, $10,000 more dollars by turning over suspected Al-Qaeda or Taliban members. We know from the first edition of the biography of President Musharraf, the former president of Pakistan, where he wrote about the millions of dollars that they made by turning over Arabs who they picked up in this bounty system. He was smart enough in the second edition of his book to take that out. But still, that's an issue that we have to address. And again, I think it's just really important to take a look at who really is a terrorist and what system of process are we going to use. I know some of the other members of the panel, one of the gentlemen from Carson City talked about, if anything, it's in times like these where we need to hold on to the Constitution and the rule of law even stronger, because now is the time, in the heat of war and the fear about that those documents mean the most to us and should mean the most. Now, as far as your first question, what was the reaction at the Pentagon? The film is actually dedicated to the JAGs. The JAGs are the military attorneys. They're the ones, a lot of people say, a lot of this came out because it was a bunch of attorneys who raised these issues, but it was actually, in many cases, the JAGs who raised concerns. And I think they deserve a tremendous amount of credit. Some of the prosecutors talked about, the responsibility of prosecutors. There have been a number of JAG prosecutors who have resigned. One, in fact, even turned and became a witness for the defense. Now, at the same point, again, I don't want to paint, I want to paint a full picture. A number of the JAGs feel like, as hard as this is the best way forward under the conditions we're in. And again, these are issues that we're grappling with. And for the students who are there, you are living through an amazing time. These are constitutional issues that I think only come up in times of war. And we're in it now. And again, as someone else mentioned, where we stand, what is that balance between national security on one hand and human rights, civil rights, constitutional rights on the other? That balance, that nexus, determines who we are as a country. Thank you.
Thank you, Mr. Libowitz. Mr. President, I'm going to ask you perhaps an unfair question at this time, but nonetheless, it came to us via Twitter. Do you think, based upon the evidence, I would put that term in quotes, that the detainee was part of the war crime? And then I'm going to ask you a question about the defense of those of the Boston massacre. Do you think that the individual who was showcased in the response should be classified as a war combatant?
Well, thank you for that question. I'm going to deflect the question in the sense that I don't have the full information to make that judgment on the guilt or innocence of the detainee. But what I will say and what I will emphasize today is a simple principle upon which this country was founded, and that principle is the rule of law. I established that principle before this nation even was created. This was in the 1770s during an episode called the Boston Massacre. You have to understand, at that time I was a very popular attorney in Boston. And after the Boston Massacre, the British redcoats who were charged in that crime were incredibly unpopular. As you can imagine, Boston was invaded saved, so to speak, by these British soldiers who were there occupying our city, and we disliked them very, very much. As a matter of fact, my cousin Sam Adams was a leading advocate in a group called the Sons of Liberty. The Boston Massacre was so unpopular that no one would defend those soldiers. I risked an incredible amount of influence, of prestige, honor, to defend those soldiers. The question becomes, why did I do it? The answer is the rule of law. I would later write that it was one of my proudest moments in my career, a moment of dispassion. I understood that the rule of law must prevail. And despite the ramifications to my reputation, I defended those soldiers to the best of my ability.
Thank you, Mr. President. We have precious little time remaining, and the important part of our presentation here today is to take questions from our students across the state. I'm going to ask that each of the three venues have their questions, or the students who are going to ask questions, ready to follow one another. We will rotate between the three sites. I would ask that each individual student who asks a question, please pose it to, if you wish to speak to a public defender, to a judge, to a JAG, to a prosecutor, to a judge, or to Mr. Libowitz. Please designate who you would like to pose your question to. We're going to start here in Carson City. Do I have a student who wishes to pose a question? I'm sorry, I'm in Las Vegas. The time travel with the president and all the Here in Las Vegas, do we have a student who wishes to pose a question? Mr. West, do you have a student? Please come forward so that we can have you. Excellent. Please come forward. I'm going to ask your name. This is Laura, and you are a foreign exchange student. Where are you from?
From Germany.
Please ask your question.
I wondered why the accused did not get an attorney, and how the trial determined the reliability of the evidence.
Excellent question. She's asking us why the detainee did not have an attorney, and questions about reliability of evidence. For those of us who are deeply involved in the law, the reliability of evidence is a huge question. I'm not sure what, if any, evidence was presented, but that's my personal perspective. I'm going to open this briefly for comment to all three of our panelists here in Las Vegas. Mr. Cohen.
Well, I hope Mr. Libowitz can tell us why the detainees do not get lawyers. I can't answer that question. I can just tell you that probably one of the most important things that I do, or lawyers who work with us do, is exercise the Sixth Amendment right to confront and cross-examine witnesses. It is so embedded in the United States Constitution, and obviously in this case, that is not available, and I find that incredibly troubling. But I would like to know from Mr. Libowitz why they've developed a process where lawyers aren't appointed.
Recognizing once again that the response depicts something a bit different than the ordinary trial process. But Mr. Libowitz, can you answer the question why the detainee was not afforded legal counsel?
Yes, I can. Thank you. Because the rules of the tribunals do not allow for any of the detainees to have an attorney. Now, again, this was supposed to be the first step, these tribunals, followed up by something called the military commissions. These would look somewhat more like you would expect. In the military commissions, you would have an attorney. There would be more evidentiary rules. But it's important to note that since 2002, there have only been 6 military commissions. At its height, Guantanamo held close to 800 detainees, of which, they had their CSRTs, these Combatant Status Review Tribunals, but there have only been 6 military commissions, of which only 2 actually went all the way through. The rest all went through plea bargains. But the rules of the commissions are such that the detainees do not have an attorney. As you noticed, there was one officer sitting behind the detainee. He's known as his personal representative. Again, though, by the rules, this person cannot be an attorney, and there's no confidentiality between him and the detainee. Confidentiality mostly know from attorney-client confidentiality. So what the client, the prisoner, says to his attorney is confidential. That doesn't exist here. The personal representative has to say to the tribunal whatever the detainee says to him. Obviously, the other issues at play are the fact that the detainee is not allowed to see the classified evidence against him and is not allowed to confront his accusers. Obviously, from the other perspective, it's, well, what is the fear, the danger of releasing classified evidence? And so that's what you have to play out with all of this.
Thank you, Mr. Libowitz. I want to interpose, perhaps while Carson City, via Virginia City students, if they have a question, they can come to the microphone. But I would like to tell you about a comment that came to us on Twitter. It's quite profound. What happened to Declaration of Human Rights? If it doesn't apply when we're scared and it's hard, when does it apply? I'll toss that open to any of our panelists who might wish to respond to that. When does the right of counsel, the right to be protected, the right to be provided with a fair opportunity to be heard, attach, if not in these most difficult times? Justice Hardesty? Mr. Libowitz?
I would say that's a good question. And look, these are hard times. Everyone's, after 9/11, everyone was very afraid of when the next attack would happen and what to do. But again, as the question states, if we have, bodies of law, such as was stated, or such as, the Constitution, or different principles that we hold dear, then again, if you don't hold them dear under the toughest of times, under the most dire of circumstances, then what do they mean? These are good questions.
Thank you. We have one more question here in Las Vegas. Would you please give us your name? This is Julie Thompson. Which school are you from?
Canyon Springs.
From Canyon Springs. Your question?
Why did the tribunal people tell the detainee who accused him?
Why didn't the tribunal tell the detainee who accused him?
Yes.
Is that the question?
Yes.
Okay, first of all, Julie, thank you for your question. Again, you can see, and I'm sure that Judge Baer, as a former JAG, can talk about this. You can see where the conflict comes up. The fear of, again, it's balancing national security interests. One argument would be made, if you tell the detainee who accused him, that information might leak out. And then this source, who has either turned and given information to the United States or was, in fact, maybe a plant, that source would be identified and would be, if not killed, then certainly no longer useful to the U.S. in its battle against various terrorist organizations. But of course, you can see from the flip side, what would you do, Julie, if you're that detainee and you're not allowed to know who said this against you? Obviously, as we talk about in the film, too, this goes back to something called the Magna Carta, which I can only hope all of you are familiar with. And I'm sure if not, Justice Seda could tell you about it. But it's really, it's a cornerstone of who we are. And the idea is, and something very important as well, called habeas corpus, which is actually enshrined in our Constitution. And this is really a fundamental pillar of our democracy. Habeas corpus, it's a Latin term that essentially means, bring me the body. The idea that you can't just be picked up by the king or by an executive without having the ability to go to a neutral judge or a neutral fact finder to look at the evidence and say, yes, there is reason why this person is detained or not. And you've got these competing interests going on. But again, if you can just drag people in and they don't have a chance to talk to know who said this about them, you can see the issues and the difficulties that are there.
Justice Seda, this is Jim Hardesty in Carson City. I'd like to ask Mary Brown if she could weigh in on this issue. What's the juvenile's right to confront witnesses or accusers against them in our system in Nevada?
Thank you, Your Honor. In our juvenile system, we give the full blanket of protections that are available to criminal defendants. They do have a right to have an attorney with them, and they have the right to confront and cross-examine witnesses against them when they are charged with delinquent offenses. The reason we call them delinquent offenses and not crimes is because juvenile court is actually considered a family court, not a criminal court. Our goal is partially public safety, but also rehabilitation, so that hopefully we can intervene at a time where we can make a difference and children don't end up in the criminal justice system.
Ms. Brown, this is Jim Hardesty again, if I can ask one follow-up question, Justice Seda. A kid accuses another kid of committing a crime or a delinquent offense. How is that any different to protecting the kid who is the accuser from protecting the one who accused this enemy combatant? How is there any difference in that? We're worried about protecting the accuser, or are we worried about protecting the rights of the accused? Maybe you could comment on that.
I think it's a really challenging question. We don't see it as often in juvenile court as we do in criminal court. And I think that the image that comes to my mind is actually drug cases and gang cases in the adult system, where our witnesses' lives are at times on the line and their identities are on the line. And so I think that I would defer to some of my criminal colleagues more, because we don't see those cases as often in the juvenile courts. It is difficult. I prosecuted juvenile sex offenses. I prosecuted juvenile violent crimes, and it's very difficult for victims to get on the stand and testify about what happened to them, and to do it in the view and under the cross-examination of the perpetrator. But we don't often see the situation, what we're discussing with regard to the enemy combatants, where truly the witness's life is on the line. In Iraq, the translators and the people who assist the American government, their life is on the line every single day. And they can be killed if it's determined that they aided our government. And so I would defer to my criminal colleagues in that regard. But
perhaps Justice Seda, maybe Mr. McDonald and Mr. Gardner could comment as prosecutors. How do you deal with that, protecting the accuser and still respecting the rights of the accused?
I think that's a great question to go to Winnemucca for, and I'd like you to address also whether or not the allegations that are made against a juvenile or an accused are fully vetted, that is laid out before the accused, and whether or not all the evidence against that accused is presented at the time of trial.
Well, Judge Montero? Excuse me, Justice, this is Mike McDonald, Winnemucca. As far as the question relating to juveniles, we do disclose the charge, the accusations, and we also, through a term we call discovery, but it's providing the information to the accused juvenile and his or her lawyers, the information regarding the allegations. The other question that comes up is in these, we've been talking about protecting witnesses and those types of things, and we do have instances where we have search warrants or affidavits in support of search warrants that are sealed because of pending investigations. But there is a point in time when the defendant, whether adult or juvenile, receives that information. And trying to reconcile that type of process with a situation where we've got this detainee that's sitting there 3, 4, 5, possibly 8 years in a facility and never seeing a stitch of any report as to who accused him or her of those events is difficult, if not impossible, when you're looking at our system that we use on a day-to-day basis.
Justice Hardesty, do you have questions from any of our muckers in Carson City?
We do. We have 2 questions. Go ahead, sir. Actually, I think it was already on. Go ahead and hit it again. Yeah, there you go.
My name is Joshua. I'm addressing this to the JAG Corps, but I know we're dealing with supposed terrorists all the time in Guantanamo, and not only there, but in military camps all across the Iraq and Iran, and some even in Europe. It's like, why hasn't it been considered that they are still human beings, and that why are they not investigating whether they are being treated as such or whether they are being treated as less?
Thank you. Was that question directed to Judge Baer?
Yes, I think so.
Judge Baer.
Well, I have to tell you, I don't profess to be an authority on what really has happened at Guantanamo. It's been a long time. I used to have hair on my head when I was in the Army. But in any event, I did look a little bit at what has gone on, and I know that a number of people, including the Attorney General of the United States, has actually personally visited Guantanamo Bay with the idea to do a sort of a look-see to see what's really going on down there. You know, lost in all this, I just have to say, I've had a real lucky life. And I look back on it and I can't even believe some of the events I've been part of. On December 20th, 1989, I was sitting in my office, and next thing you know, I was in the jungle in Panama for 3.5 months when we went down to get Noriega. I was deployed with soldiers from the 6th Infantry Division of Fort Ord to go into there. And I spent the time in the jungle with the troops for 3.5 months. And, none of this is easy, but I think what really is going on here is our government, I think we should all be proud of what we're trying to do with all this. I really do believe that. And what we're really trying to do with this is establish a procedure that makes sense given what was brought upon us, that changed everything. I mean, it really did. I know I said that before, but things have changed. And we're just trying to do the best, I think, to find out what to do in this modern battlefield. I mean, I think, when I saw that a lot of people here felt as though maybe we should not classify the individual in the film as an unlawful combatant. And I respect that. I really do. And I don't have a vested interest in this fight. But something I think does need to be mentioned. There is a national security concern here. There really is. In a perfect world, it would be great if everything was not confidential in these hearings. However, they are confidential because there are national security concerns that I think sometimes do rule the day on this. I mean, here we have an individual charged with money laundering, and that money allegedly was used for weapons for Al-Qaeda. We have an attempt to detonate a bomb at a U.S. embassy. One thing that we don't have here today is any of the actual evidence that was classified, that was kept confidential, that these 3 JAG officers would have been privy to. And so maybe the smartest person in the room is John Adams, who, when you asked him to give a judgment as to whether to classify the individual as a detainee or not, he deferred judgment. Better than any judge here could have probably ever done, because the fact is we really don't have that evidence. And it is kept, I think, confidential for a reason. And what I thought about driving in here today was this. God only knows what our government really did to get the information that led to that courier that then led us to bin Laden. But I bet you a lot of the things that we had at our disposal were kept classified, kept confidential for national security reasons, and look what happened.
At the risk of a gentleman spending 4 years in detention without knowing who, how, or what was being used against him?
Well, this is real sad. There's no doubt about it. I mean, it is. Do I personally or even professionally like the amount of time that these individuals have spent there? No. I respect Phil Cohn, our public defender, tremendously. We've been friends a long time. These issues struggle at our hearts because we do care about fairness and due process and treating people in a humane way. But I really think they are trying to do this the best they can, given the really unfortunate modern battlefield that we now have to find a way to deal with.
May I add to that?
Yeah, Mr. Libowitz, this is Jim Hardesty in Carson City. I wonder if you could follow up on the student's question here, which I think really goes to the issue of what is our government doing to examine the human conditions of the incarceration of these individuals. Is that right, Josh?
Mr. Libowitz. Perhaps we've lost connectivity to Mr. Libowitz. We're going to have our IT folks see what they can do to bring him back with us. We'll go back to this question. As we are doing so, is there another question that we might address?
Yes, we have another question in Carson City.
My name's Lindsay, and I actually kind of have two questions. So my first one is towards the DA. As a lawyer, what is the definition of guilt?
Thanks, Lindsay. This is Gerald Gardner from Carson City, and under the law, the definition of guilt is proof beyond a reasonable doubt. Proof beyond any doubt that is reasonable that the accused committed the crime he's charged with. The state has to prove every element of the offense. And when I say element, meaning not only that they did the acts that constitute the crime, like say a burglary or an assault, but that they had the proper intent to do these acts. And we have to prove that beyond any reasonable doubt. So that's the best definition of guilt I can give you as far as legally.
Was there a second question?
Yes. And then Mr. Hudson, you raised your hand when they asked who thought the detainee was guilty. In your opinion, is there any reasonable doubt there?
I think you may have misinterpreted my gesture. I didn't raise my hand. I would not have classified the detainee as an unlawful detainee or an enemy combatant. Excuse me. I didn't take a vote on that issue.
Perfect. Okay.
And by the way, with respect to your question, the standard or the burden of proof that Mr. Gardner has identified in a criminal case, whether someone is guilty, is quite a bit different than the standards that the panel in the military tribunal was trying to address as to whether to classify this individual as an enemy combatant. And yet, did you all notice the ultimate result of the detainee is the same? The detainee has still been in prison in a foreign country for 4 years, and likely, depending upon how the captain votes, will be in Guantanamo Bay for another 4 years before there's ever a trial. And so, whether the burden of proof is guilt beyond a reasonable doubt, or whether it's simply a classification decision, the result of the detainee is incarceration is the same.
Deprivation of liberty, in other words. Mr. Libowitz, can you respond to the question that our young student asked regarding the human condition and what, if anything, is being done to protect that?
I'm sorry, in terms of the human condition?
Yes.
Is this going back to Joshua's question? I'm sorry.
It is going back to Joshua's question, yes.
Yeah, no, thank you. I don't know where you are, Joshua, but I appreciate your question. And sorry that the clouds covered the satellite and I got lost there. I think you're raising a really good point. These are hard decisions, but a couple things to keep in mind. First, remember that you asked about the numbers of people there. Guantanamo housed, even at its height, less than 2% of all the detainees that have been held since 9/11. That's really important to know, and we only happen to know about them because of these 4 major Supreme Court cases which held essentially that the United States courts have jurisdiction over Guantanamo. So the vast majority of the detainees are held in Afghanistan, Iraq, formerly in what were known as black site prisons in other parts of the world, although we have been told that those have closed. But again, that's an important thing to know. As far as an acknowledgement of their human rights, that's a matter for all of us here to think about. When we did the screening at West Point, there were students there not much older than you, and they were asking a lot of very pointed questions because they knew that in a very short time they would be sitting on tribunals like the ones on the film. And how we address that is really important. Again, these are questions for our country to determine where we stand. And I look forward to hearing what you and your generation plan to do about that.
Mr. Libowitz, brief follow-up question. How many tribunals have been held and how many are held annually, if you know?
Tribunals, so you mean the Combatant Status Review Tribunals?
Yes, sir.
There were approximately 700 held, and they have not been held since 2007. There were, in addition to the Combatant Status Review Tribunals, there was something known as ARBs, or Annual Review Boards, which would essentially do the same thing. They would review the information on an annual basis. These were locked into place in 2007, but it's important to note that the decisions, the classifications from these CSRTs and ARBs continue to this day, and they are the basis of the continuing detention for the detainees at Guantanamo. And we know now that the CSRTs, or something like the CSRTs, are going to be taking place in Afghanistan.
Thank you, Mr. Libowitz.
Mr. Libowitz, this is Jim Hardesty in Carson City. I'm sorry to interrupt, but as the detainee in the film, what was the year of the transcript, and is that detainee still incarcerated?
Well, thank you for the question. It's important to note, obviously, this is a composite detainee, as are the JAGs, the tribunal members. And again, it's important to note, too, that the way this worked, not all of the tribunal members were JAGs. Essentially, from 2002 to 2004, there were no tribunals. There were the position of the former administration was that there was no due process required for any of the quote-unquote unlawful enemy combatants. So it was only in 2004, with two Supreme Court cases, Razul and Hamdi, that said, there was a famous quote, some process must be provided. Within 2 weeks of those Supreme Court cases, the Combatant Status Review Tribunals rules were written. And within 6 months of that, the CSRTs started. And, they happened so quickly, and there were so many of them, and Guantanamo is a small place, that they weren't prepared for what was going to happen. So many of these things actually took place in little trailers. And there weren't obviously enough JAGs or anything like that to do this. And in fact, according to the rules, the tribunal members don't have to be JAGs. They don't have to be attorneys. Some took place without any JAGs. A couple would take place with one or two. So it's a really fascinating history, which I wish we had more time to delve into.
Thank you, Mr. Libowitz. Judge Montero, do you have questions in your courtroom?
Yes, as you may see from the video conference, we've changed seats here. A couple of students have come forward and would like to ask some questions. You may proceed. Go ahead.
Hi, I'm Sterling from Lowry, and I had a question about if there was any requirement on the length that they can be detained without even being told or without even having a chance to explain or be told if they are guilty or not, because in the film there was the 4 years before he even got to talk to the tribunal, and I wondered if there was any rule on that.
There was none. After the Supreme Court cases, as mentioned in 2004, these CSRTs were set up, but, some people, there really wasn't anything until then, and then you would have your CSRT and wait. And then the annual review boards were set up, so you would have at least an annual hearing based upon typically the same information or maybe more information that would come up, but there were very little rules.
And CSRT, again, is Combatant Status Review Tribunal, correct?
Correct, yes.
Do we have another question, Judge Montero?
Yes, Justice Soter, we do. I have another student here would like to ask a question. You may.
My name's Jesse from Lowry, and mine's a more recent question. I was wondering if you could explain just the logic behind President Obama's not releasing the photos of Osama bin Laden.
He didn't tell me.
I was wondering if maybe you had an inkling.
Well, look, I'm honored that I have a President of the United States introducing the film today. So thank you, President Adams. No, obviously, only what I've read and seen in terms of not wanting to. And I understand this. We have troops on the ground, and the idea of not wanting to inflame any passions by showing those pictures, which might, if anything, only add fuel to the fire. So obviously, it's a choice, and as you can see, there are a number of people who think that the wiser choice would be to show them to dispel any doubts. That's all I know. If someone knows more and wants to comment, please.
May I follow up, Judge Montero? Why is the student concerned? What is the basis of the student's concern about release of the pictures?
My biggest concern is that it just means that there are, radical Muslims and Al-Qaeda and stuff out there that if their photos aren't released, they can come up with the conspiracy theories that maybe he's not dead, and it could arise with problems.
Thank you. Do we have another question, Judge?
I do. I have another question, but before the next student asks questions, I actually have one of Mr. Libowitz. Can you tell the students here from the first detainees at Guantanamo until to the present, how have those numbers changed, if you know?
You mean on Guantanamo itself?
Yes.
Guantanamo, as mentioned, at its height, housed approximately 800 detainees. We are now down to, again, approximately 150-ish. Now, what's important to note is you say, well, how did they get out if we didn't actually have any trials, or there have only been 6 military commissions? Again, 4 of those military commissions ended in plea bargains, in which case, such as David Hicks, who was an Australian, his plea bargain was he admitted to certain crimes, and then he was sent back to Australia. Australia released him 6 months later. Now, they do have a monitoring program. He's not allowed to leave Australia. He has to appear, not unlike a parole system. But the vast majority of people who were released for political reasons. They came from countries that are viewed as our allies, such as Saudi Arabia or England, Jordan, Lebanon, and they were released for those reasons. In some cases, against the military's assessment of their potential risk. So, again, what we happen to know about is what's going on in Guantanamo because of these 4 major Supreme Court cases that took place between 2004 and most recently in 2008 with the case of Boumediene. We don't know nearly as much, obviously, about what's going on in Afghanistan, Iraq, or other places around the world.
Thank you, Mr. Libowitz.
Justice Ada, do we have time for one more question? I have another student here at the table.
Yes, and I wanted to make note, for those of you who are able, we are going to continue beyond our 10:30 time to allow as many questions as we possibly can within a reasonable period of time. We have several students here still in Las Vegas who are going to be asking questions, so we will continue as long as the participants are able to do so. Please proceed.
I'm Jessica from Lowry, and as far as I could tell from the video, that when a detainee was brought in front of the people, I just forgot their names, the tribunal, they were going to be deemed as enemy combatants. If you were to deem someone as an enemy combatant, isn't that pretty much as calling them guilty?
That, and I think there was, if I'm correct, it was Judge Hardesty who was talking about that. That became the issue, as we noted in the film, and has become an issue, to many people. That was the problem. If you classified someone as an enemy combatant, then essentially they could be held technically until the end of the war on terror, whenever that might be.
Date yet to be determined.
Date yet to be determined.
I'm going to come back to it.
Becomes part of the problem.
Thank you, Mr. Libowitz. We're going to come back here to Las Vegas. I believe we have a question. Would you tell us your name?
I'm Kenzie Lee.
Kenzie, let's go from
Colorado.
Please proceed.
Okay, my question is, why would they not shed more information about where they got their info? Why not read the exact statement what the person said who accused him?
I'm happy to answer that unless someone else wants to jump in.
Mr. Libowitz, it's to you.
Okay. Again, that is a very good question. And the reason being, as was given, this is classified information. And the idea being somehow if that gets out and the detainee is released, he returns with that information, and within that there might be some tidbit, some small piece that could be used by a terrorist organization to either capture, someone who has been trying to help the United States, or might better help a terrorist network improve their defenses against infiltration by the United States or our allies. But that's the reason that is given. Of course, what's so fascinating with this is, I know one of the things I didn't have a chance to talk about was something that Judge Baer mentioned, in terms of, we don't have all the information. Obviously, the problem was that the tribunal members didn't have all the information either. They were not provided with all the classified information. Again, they would always say there are other government agencies that have classified things beyond them. I did have the chance to answer another one of Justice Sada's questions. After the screening at the Pentagon, I was invited to travel to Guantanamo to serve as a legal observer to some of the hearings surrounding the military commissions. And it was fascinating there because the same thing, the military judges, they didn't get all the information. And they would often ask, the military prosecutors, why don't we have all this information? And, the military prosecutors would say, pardon us, Your Honor, but we don't have all that information either. That has been classified by other government agencies. And you can see, again, the concern, hey, there's national security reasons here, we can't do this. But then on the flip side, it's very hard. How do you determine someone's fate when you don't have that? I do agree. I think what I found, and again, why the film's dedicated to the JAG, I think these people are working very hard, and they're all very smart and patriotic people who are trying to figure out the best way forward. And again, they're not the ones making up the rules. They're doing the best they can with the rules they've been given in this time period they're given.
Before we go to our next question, I wish to thank, before some of our students have to leave us here in Las Vegas, and I want to thank the teachers, the deans, and the assistant principals who so wisely took time out of their busy days and brought their students here for us today. Ms. Galt, who is the assistant principal at Canyon Springs High School, Ms. Rush, who is I can't read this writing, I'm so sorry. But thank you, Ms. Galt, also from Canyon Springs. Mr. West, the dean at El Dorado, and Ben Wood, a teacher from El Dorado, thank you for bringing our students here. I would also be remiss at this last few minutes that we might have together if I did not mention the State Bar of Nevada. The State Bar has been instrumental in helping us to coordinate our law day activities. All of my colleagues, three of the Supreme Court justices right now, Justice Pickering, Justice Gibbons, and Justice Cherry, are actually on the east side of our state holding arguments, so that they've taken law day on the road, so to speak. And again, being a part of this opening our doors and explaining what we do and how we do it. We're going to continue to take questions as long as we are able to do so. I know here in Las Vegas some of our students have to leave, but I also know that Mr. Cohn, as a public defender, wishes to make a comment before we go. Thank you all for being here. If you have to leave, I would ask that you do so quietly so that our partners in other locations can continue to be a part of our proceeding here today. Mr. Cohn.
Thank you, Justice. In answer to your last question about all of the evidence, there have been two cases, and the system works. I really believe the system in the United States works, and justice almost always prevails. There are two murder trials that I did or I supervised over where I believe the jury came up with a guilty verdict that was completely wrong. And in both cases, the evidence was primarily from snitches. And we did not get all of the information as to what those snitches had received in the benefit. And I found it incredibly troubling. And I think that's what's going on in Guantanamo. If you don't know what the motivation was of the person that gave the information that caused the tribunal, bad things can happen. Now, I'm happy to say, and I don't just say this because Justice Sada is next to me or Justice Hardesty is in Carson City. In both of those cases, the Nevada Supreme Court reversed them, and justice was later done. But the two cases in my career that stand out and bother me the most were because we didn't have all the information on the motivation of a witness, and I find that very troubling. And it doesn't happen often, but it happens.
Thank you, Mr. Cohn. Do we have other questions here in Las Vegas? Please step forward.
My name is Joseph Simmons. I'm a senior at El Dorado High School, and I'd like to know, what do you think might have happened in the result if the man was found guilty, and do you believe it would be a trigger effect?
His question was, what do you believe will happen with respect to whether or not the alleged enemy combatant who appeared before the tribunal, what do you think will happen to him, and what happens to him, will that affect others who come after him?
Yes.
Mr. Libowitz?
Well, I mean, I think you just have to look at the numbers from Guantanamo to know that the vast majority of these people were found to be unlawful enemy combatants. And so I think it's quite likely that what literally happened would be that he would be found to be an unlawful enemy combatant. There was a very important study done by a father-son lawyer team out of Seton Hall, and I just like saying father-son lawyer team. And they did an analysis of all the CSRTs. What they discovered, and I don't have the exact numbers here, but the vast majority were found to be unlawful enemy combatants. Of the few that were not, the Department of Defense held a second CSRT. These are known as the do-over CSRTs. And in that second round of CSRTs, most of those people were, in the second CSRT, found to be an unlawful enemy combatant. In the few cases where those detainees were found not to be unlawful enemy combatants, the Department of Defense held a third CSRT. And you can imagine. So, again, though, still, most have been released either to their home country or to a third-party country that took them in. Obviously, what you ask, what is the result of that? I think that becomes the issue that people talk about. The fact that this is this war on terror is a public relations war. And, what are the effects of that? What are the effects of something like Guantanamo? I mean, I think you can even look at General Petraeus, who has advocated shutting it down. The fact that it is a recruiting tool, like Abu Ghraib or other things are, for terrorist organizations. And obviously there have been a number of other people, military folks, generals, admirals, who have come across and said the same thing. These are the issues we really have to address. Again, it's one of those things of, if you win a battle, do you win the war? And if the war is a long one, not unlike the Cold War, and many would say we won the Cold War because we were perceived to be, if you will, the good guys. And I think, I don't think there's any doubt that we're the good guys here again, but it's, again, how we portray ourselves and how we act. I think Peter Riegert, one of the actors from the film, says a lot, it's easy to say things, but it's what you do and your actions that count.
Thank you, Mr. Libowitz.
Okay, yeah, thank you.
Thank you. I want to bring our president back for a few moments. President Adams, do you have any comments that you'd like to add to today's proceedings?
Today's discussion demonstrates that we must all continue to fight and preserve a right to access to justice, just as I had to do in my day. I'm proud that the courts and so many others in Nevada are pursuing that just cause. And I remain astonished at the knowledge of our students and the technology that made this all possible. And I thank you all for being here.
Before you leave us, Mr. President, I would like to give you my most profound thank yous for being here. Your historical perspective has meant a great deal to us. And for those of you who don't know, John Adams is actually Jeff Hinton. He is a history teacher and social studies department leader at the Northwest Career and Technical Academy. And Jeff, or Mr. President, your participation here has made a tremendous difference to our ability to talk about how far our system has come and how much we still have to protect. With your rule of law and our proceedings here today, thank you for your time.
Thank you.
I would also, and we're going to continue to take questions, but I want to be sure that all of the necessary thank yous are made before we lose too many of our remote audiences. Mr. Libowitz, without your thoughtful and provocative film, today would not have been possible. thank you for that and for your participation here with us today.
Well, thank you. And I also want to thank the director of the film, Adam Rogers, and our executive producers, the University of Maryland School of Law and the law firm of Venable LLP. And for those who are interested in seeing the film or working on it in class, they're actually through the great organization called Street Law. You can get the film and the teaching tools either through your Law Day Live website or at streetlaw.org/the-response movie.
Thank you, Mr. Libowitz. Also, it is important to note that one of our partners was Project Real here in Clark County, and they always support our desire to take justice to the people, to our students. Thank you for that. Similarly, school districts throughout the state, Carly Mull from the Clark County School District is always the centerpiece of our planning and execution of Law Day. Thank you so much, Carly. The staff here at the Supreme Court, at every level, the administrative office of the court, many of our assistants here in the Supreme Court are also instrumental in making this possible, and I can't thank you all enough. Our panelists throughout the state who have taken time from busy schedules to be here, I know that they stand ready to answer questions, additional questions at any time. If you wish to reach out to them via Twitter or via our Supreme Court website, please send a question, and I will be certain that they get forwarded to the right participant for their response. And for the students who took time out of their schedule to be here, who care enough about what justice will mean and what the rule of law will be in your generation, I thank you for your time and your commitment to being sure that there is access and justice for all. If there are other questions, I would certainly entertain them. Judge Montero, Justice Hardesty, Mr. Gardner, do you have other questions in your venues?
Justice Staita, this is Judge Montero. I have students just lined up here to ask questions. However, I also have to let a couple of the classes go in just about 5 minutes, so I'm going to allow them to ask a few questions. But before we do, I just want to make a few thank yous as well. Thank you to the panel here, Mr. McDonald, Mr. Pasquale, Mr. Sturmitz, for your assistance today. I'd like to thank the schools, Lowry High School, McDermott High School, and the Winnemucca Junior High School for being here. What a wonderful turnout, over 60 students here in the courtroom today, and I suspect many more that are watching on their computers here in Humboldt County. Justice Staita, with that, I'd like to turn it over to a young lady who's seated here in front of me who'd like to ask a question.
Please proceed.
My name is Maria Elise Ketris, and I'm from Lowry. And I just have a quick question. How long, I know we've been fighting ever since 2001, the war on terrorism, but have there been any acts of terrorism before that we've been fighting that constitute the war of terrorism?
Yeah, I'll take that. Yeah, there have definitely been other acts of terrorism. I mean, we don't have to go very far. Al-Qaeda, prior to 9/11, attacked the USS Cole, killing many of our sailors, damaging a ship. They blew up 2 embassies in Africa. Prior to that, you had the first World Trade Center bombing, if you're familiar with that, back in the 1990s. There have been acts of terrorism throughout. I mean, one of the big issues, and I would love to hear what the panel has to say about this, it's the whole idea of, do we have to use military commissions versus using our court system, our Article 3 courts, Article 3 coming from Article 3 of the Constitution. It's the idea that all of those prior acts of terrorism were tried in our courts. There was never an accusation that any confidential information was ever leaked. Cases can be held in something called in camera, where essentially you close down the courtroom. You only allowed, the judge, the attorneys, people who might even have just high-level security clearance to be present. So there were ways of doing that. The success rate of our excellent, prosecutors and in the Department of Justice and the U.S. Attorney's offices was over 95% in these cases. And even since 9/11, the cases that have gone on to Article 3 courts, such as the case against Moussaoui, who was said to be the 20th hijacker, he was found guilty. He was sentenced to life in prison. I think the courts, Article 3 courts have a very successful track record. So I'd love to hear from some of the other panelists on that.
Panelists here in Las Vegas, comment with respect to use of military tribunal versus Article 3. And or Justice Hardesty, Mr. Gardner, Judge Montero, please feel free to respond.
Justice Ada, I'll respond. This is Gerald Gardner in Carson City, and I think it is the central question. And if you look at the opinions by the United States Supreme Court to rule on some of these issues, these were extremely close decisions. The most recent case that Mr. Libowitz mentioned, Boumediene, was a 5-4 decision, and that's as close as you can get. There's a big distinction, I believe, between the trials of terrorists who commit crimes on our soil and legal proceedings against people who are classified as military combatants or who are sought to be classified as military combatants. One of the most interesting parts of this is to read the dissents in some of these opinions. Look at Justice Scalia's or Chief Justice Roberts' dissents. And some of the things they point out are that even under the Detainee Treatment Act, which was before the Supreme Court ruled that these detainees were entitled to habeas corpus, these detainees had far more legal procedures, legal process rights than had ever been given suspected enemy combatants before, certainly enemy combatants who were captured on foreign soils. And the issue of the 98% that are not in Guantanamo, I think the alternative is going to be that the Guantanamo detainees are not going to be brought, people like that are not going to be brought to these soils. These decisions are going to result in those detainees being turned over to either foreign military custodians or simply kept in foreign detainment camps where it's far clearer that they will not get the benefits of American due process, even under the military tribunal system.
Justice Sada?
Further comment from any of our other panelists? Judge Montero, do you have other questions?
Yes, if you wouldn't mind, I have a couple of other students up here that would like to ask some questions.
We'll take a couple more.
Limited here, so let's go ahead.
This question is directed towards Mr. Levitsky or
Libowitz?
Libowitz, sorry.
You were close enough. It's okay.
My question is, in the film, the JAG officers mentioned something about the detainee being sold out by an informant who was allegedly being tortured. My question is, how would they test the credibility of this testimony, if you will?
You ask a very good question, and I hope that you saw, we tried to address that in the film. That becomes part of the problem. How do you determine the reliability of that evidence? And there was nothing really provided to the JAGs or to the tribunal members, because again, they weren't all necessarily JAGs. In fact, most weren't. How do they determine that? Becomes very hard. And again, part of the issue is they don't have the opportunity to talk to the informant. They don't have the opportunity to see all the classified evidence. And it created, in talking, when we screened it now twice at the U.S. Army JAG School, when we screened it at the Pentagon, and in talking to people who served as both prosecutors and defenders in the CS, in the military commissions, these are the issues that are continuing. How do you do this? How do you make that determination? There's no easy answer.
I would like to echo something. Yes, I would like to echo something that you mentioned that seems to be a recurring theme in our questions about evidence and credibility. One of the things that I'm most proud of with respect to the work that I get to do is what our President Adams talked about, what all of our panel members will note and respect, and that is the rule of law and the opportunity to confront those who are our accusers in the everyday judicial system that we are most familiar with. For the most part, evidence is not only presented, but it is tested through a series of legal rules to be sure that it is, in fact, credible and reliable. And anyone who is confronted with that information is also entitled to claim that the information is not valid, not accurate, or to challenge the person who is bringing that information to be used against an accused. And I'm very proud of our system because I believe that it perhaps differs from the tribunal process that is depicted in your film. Our system does afford, or make every effort to afford, a clear path to credibility, to relevance, and to an opportunity to see all the evidence and or witnesses who are being brought against those who are accused of crimes. I hope that our panelists across the state would agree with that assessment.
Justice Seda, I am going to, this is Judge Montero, I'm going to have to let some students go, but I have one young lady that's been waiting here quite some time. If you wouldn't mind, I'm going to allow her to ask a question, and then we'll probably have to break.
Certainly. We will take this as our last question. We've lost our students here, I think, both in Carson City and in Las Vegas. So this is the concluding question for Law Day 2011. Please proceed.
I'm Cassie, and I'm from Lowry. And my question is about the tribunal process. How exactly do they determine whether or not that they're a threat to the U.S. using the evidence?
Mr. Libowitz, can you address that to you?
Yeah, can you still hear me?
Yes.
Yeah.
Can you hear me? Okay, great. You're asking good questions. I mean, these are the fundamental issues. They have been determined by the Department of Defense at that point to be a threat to the United States, that they were a member of Al-Qaeda or the Taliban or some other terrorist organization. They've been turned over by somebody or picked up somewhere. And again, remember, it didn't have to be on the battlefield at all. In fact, most of the detainees were not picked up on the battlefield, which is another issue that we could talk quite a bit about. So it's just really these files that were created on them listed what their alleged offenses were, and they were determined to be a threat. We don't know more than that. And again, it's very hard. I don't think anyone should. I would hope one of the things you can be proud of, like you're seeing here, is I think our military has overwhelmingly done a really good job. These are very difficult issues. Imagine fighting wars and people are shooting at you and there are IEDs and you're trying to do the best that you can, and you're working with the rules that you've been given. So as I hope you can see with the film, we really tried to take this from the level of those tribunal members, those officers on the ground who are tasked with the incredible responsibility of trying to determine the right thing to do. And I think they deserve our credit. But at the same point, you have people's lives, in the detainees, and I would hope what we get from what the tribunal process is, it's very hard to determine whether they are guilty or innocent. There's not, with the evidence that you've provided, it's very hard to make that determination. And many would say there's not enough evidence to actually make a real determination. So I think these people are trying to do the best they can with what they've got. So then the bigger issue is what rules should they have?
Thank you, Mr. Libowitz. To all of our panelists, to all of the schools who are listening on our webcast, you can continue to view, access, and tweet, talk to us. If you go to the Nevada website, all of the lesson plans, further information are available to you. Thank you for being a part of Law Day, and let the rule of law always be as important as it is here today in this courtroom. Thank you all.
Thank you, Justice Seda.
Thank you.
And thank you also to our associate producer, Joe Scari, for all he did setting up today.
Thank you.
Thank you all.